That's not the way I read this. It says,
Oh, I agree. That's
Hold
not
on.
the way it reads.
Hold on.
But that's talking to him.
but hold on. Alcohol, substance alcohol, age at first usage 19, date of last use February 1st, 2026.
A man stands before the judge for felony DWI, hoping his health problems in years since his last convictions might earn him probation. But the courtroom file tells a darker story: multiple felonies, revoked probations, and a blood alcohol level of 0.223 after police found him passed out in a running car. As the arguments end, the judge delivers a decision that could still send him to prison for 10 years.
23 CR 1728 is called. Are you Curtis Adams?
Yes, sir.
And you were here with your attorney, and Mr. Ham, I think, is the prosecutor.
I've been done from here. I'm sorry, I've got.
That's okay. I know you're doing a lot of stuff. Earlier, in this case, you pleaded guilty to the third-degree felony of operating a motor vehicle while intoxicated. And a pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it?
The state has, we don't have any objections or changes, Judge.
Say,
Yeah.
All right, it's made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 10 years in prison. So we are looking at no less than 2, no more than 10 years confinement in prison. And I think probation is allowed,
Yes, sir.
for this as well. There is an elephant in the room here, though. We got 7, no less than 7 misdemeanor convictions, no less than 5 felony convictions. And these include the DWIs that were used as the basis of the underlying 2 prior DWIs that vault this new DWI into a third-degree felony range. But your criminal history is not good, according to this report. All right. Okay, go ahead.
Your Honor, this is a case that occurred 3 years ago, December the 23rd of 22. We would like to point out that the prior DWIs were 13 and 14 years ago. The felonies, as the court has brought out, they all occurred 34 years ago. One was 26 years ago, and the other was 22 years ago. Since my client was arrested 3 years ago on this charge, there's been no prior problems, and in fact, he gave up. I mean, he does not have a driver's license, and he also gave up his car. He does not drive, will not drive. If the court would consider probation, he wants that to be a condition of his probation, that he will not drive. Now, in addition to that, he is disabled and has substantial medical problems. He's been disabled now for approximately 3 years. He recently suffered from an aneurysm about 2.5 years ago.
What?
I'm sorry, an aneurysm.
Okay.
I'm reading from the PSI.
Okay. When did that happen?
He was in a coma for 2.5 months.
Maybe about 2.5, 3 years ago.
After this event or before? After this. Okay.
He was in a coma for 2.5 months ago, 2.5 months at Kingwood Medical Center. He had a pacemaker installed due to his ongoing heart problems. He has severe high blood pressure, and he's on all kinds of different medications. His sister, who is a traveling nurse, helps maintain, his medical records and assist with his medical needs. he is disabled and it is not working, is not going out in public, with the exception, and I'll give the court and the state copies of letters written from family and friends showing that he spends his time taking care of the elderly and trying to be a mentor to young people. There was, I talked to extensively, there was a misunderstanding between he and the probation department, and it's probably his fault. He clearly recognizes that he is an alcoholic and wants to participate in any kind of treatment. The probation officer who wrote the report talked about that he would be a good candidate for JCDI, receiving intensive outpatient treatment program. And he is very anxious to do that. And the he has, the PSI talked about a long time ago, like 30 years ago, that he had some type of treatment, but he has not had any type of DWI alcohol treatment, since that time, and is quite anxious and quit living this way. He has abstained from drinking, except the PSI did talk about that back on his birthday, he did have one wine cooler. And he acknowledged to me that that was a mistake, but he did do that. So, with all his significant health issues, we think that it would be in the best interest, and well, not only his health issues, but also the length of time of his extensive of those felony priors that he has, 34, 26, 22 years ago, and how he spends his life now. We would urge the court to allow him to go on an intensive term of probation, receive intensive treatment for his alcohol problem through ISF. He is perfectly willing to wear any kind of alcohol device that the court wants him to wear. He is not, since this thing happened, he does not drive a car. And
How does he get around?
his family drives him everywhere.
Somebody drives you around?
My brother-in-law was 50.
Okay.
His brother-in-law's here with him this morning. And so that's where we're coming from.
Okay.
And that's what we're asking the court to do.
All right. Stay.
On page 7, Officer Riley, who's in the courtroom, does a really good job of summing all this up at about 8 lines in. So during the substance abuse evaluation, the defendant minimized his drinking, rationalized his behavior, denied being an alcoholic despite acknowledging problems from alcohol use, showed no accountabilities for his action, which persisted with daily consumption of a 6-pack after work or a 12-pack on his off days before the current offense, with his last reported alcohol consumption occurring on February 1st, 2026. Every probation that he's had an opportunity in the past has been revoked. He's never successfully served. He was, at the point in time before we made this deal, he was looking at a habitual offense. He was indicted, and we could have proceeded to trial, and he would have been looking at 25 to life. We did not do that because the last sentence, then the highest sentence that he's received, was a 10-year sentence. We took into account all those things that Mr. Smith is arguing about the length of time in which this circumstance has been. But the reality is he served 3 8-year sentences and a 10-year sentence. I don't agree with giving him another chance at probation when every opportunity that we've provided by the state of Texas at some point in time, he's just kind of thumbed his nose at it. And to walk in and say that it's a misunderstanding, he not only told that officer over there that he's not an alcoholic and that he doesn't need it, he said the same thing when he did his substance abuse assessment.
How about that?
What's been understanding? I do need him for that.
How did they misunderstand you? You speak English, right?
Yeah, but I don't recall saying that.
It's all a part of the substance abuse
In fact,
assessment.
after work, I haven't worked in a couple of years.
We're lucky to actually that he's standing there. Because on December 23rd, 2022, he fell asleep with his engine running, foot was on the brake, and that's because that's how intoxicated he was.
Shame of it. It took over 3 years to get here. That's what's a shame.
At one point in
This
time,
is terrible.
the state has some responsibility for that because initially the lawyer that was assigned, we discovered was that represented Mr. Adams in the past. That's how I inherited the case, Judge. That's some of the delay. But the reality is he still is lucky he's alive from that circumstance. He was in a running car, asleep, whenever law enforcement had to get involved to bring him here to court. And yes, it has been this long, but the reality is that was just the beginning. He refused to assist at that time. He wouldn't voluntarily give his blood. We had to get it from him. And he was at a .223. And all behind times in which this is a person who has so much of a history that he's in your courtroom with a DWI. I agree the man needs help, but I'm glad to say that the Texas Department of Corrections has so many good programs that can assist him with that. And I believe that the only just and right sentence here is a 10-year sentence, and he can seek his help there.
Go ahead.
Your Honor, and this could be, and I told the court earlier, this misunderstanding about him being an alcoholic, after talking to him, is obviously his fault. He was, in his mind, he was concentrating on the fact that, I mean, he's had such lack of education about what is and was not an alcoholic. He interprets that to be like, well, do I have to have a drink today? And in his mind, since this happened 3 years ago, he hasn't drank, except for that one time in his birthday, when a wine cooler.
Say that again?
Sir?
Say that again?
In his mind, he hasn't had a lot of education at all about what is and what is not an alcoholic. And in his mind, since back 3 years ago when this occurred, he has not drank. He gave up his car. He gave up his license, and the only time he drank is
he hasn't been drinking since this event.
Sir?
He hasn't been drinking since alcohol since this event.
No, Your
But where's the probation officer on this one? Who is that? That's not the way I read this. It says,
Oh, I agree. That's
hold
not
on.
the way it reads.
Hold on,
But
substance.
that's talking to him.
But hold on. Alcohol, substance alcohol, age at first usage 19, date of last use February 1st, 2026. That's last month.
That's what I was talking about, the wine cooler on his birthday.
And then this says frequency, about a 6-pack of Budweiser beer daily after work and about a 12-pack on off days.
That was before this offense.
Well, it doesn't. So what is the timing on this? That's what's unclear. Is from the probation, they're saying that he's been abstaining from alcohol, but then this says this February 1st.
I mean, even Jimmy indicated that that was before the arrest date.
If you look at page 7, Judge, that's where I think the officer kind of clarifies and agrees with Mr. Smith.
I want to know when he was last drinking 6 and 12 packs of beer daily. When was that?
That was before the
When before?
That's his reported, that's what he reported during the substance abuse assessment. Is that
When before? How?
That's what he was doing at the time.
That's when I.
Oh, up until that time.
Yes, sir. Yes, Judge. And to be honest with you, Your Honor, I had to reread that a couple of times while Mr. Smith was
Right.
talking to make sure I understood that correctly.
Okay.
And
Okay.
so his prior felony convictions, he was like, what, he was 19, 20 years old, very young.
Were you old enough to know better? That's a test. But we got this trespassing conviction here kind of recently, but I don't know what that's all about. But putting that one aside,
That's when you had the
it's a decade.
Thinking that was my uncle's house.
It's over a decade since you've been in trouble, right?
Yes, Your Honor.
Okay. What inpatient treatment on probation do we have for something like this?
Inpatient treatment.
Yeah.
Safety or something.
Yeah, he's got a serious health problem that I think, I just don't think you just walk away from and you're fine the next day. I think we need some treatment that's inpatient treatment for a while. So we can be assured that he's not going to hop into a 1,000-pound missile and drive around and then turn in, and then while you're driving, you become comatose with the engine running. And everything, the doors locked and windows closed. That was February 1st. I'm sorry, that was on December 23rd of 22. You're lucky. I mean, that could have been carbon monoxide poisoning for you. Well, so what on the safety, how long is that?
It could be 6 to 9 months.
Mm-hmm. He's gonna go somewhere for a while.
Yes, sir.
All right. Anything else?
No, yeah.
Anything to say?
No, Judge.
What I'm going to do is I'm going to find, if nothing further, there is sufficient evidence presented here to show that that you have pleaded guilty voluntarily, knowingly, intelligently to paragraphs 1 and 2 of this indictment, which constitute the 3rd-degree felony of operating a motor vehicle while intoxicated, a 3rd-degree felony. And this is proven beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt of this offense. Finding you guilty of this 3rd-degree felony, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. This is the cap of 10 years confinement, which is the plea bargain. I am following that. Now, I am going to suspend that prison sentence, place you on probation for 10 years. There will be terms and conditions of probation, which are not only normal and customary for DWIs, but are special in this particular case. One of the conditions is you will be placed into custody here. You will attend and successfully complete the substance abuse felony punishment facility program. It's an inpatient program. Your feet aren't going to hit the ground until you have successfully complete that, which is, how long is that one?
6 to 9 months. It's self-paced.
It's a while, but this has gone on. You have been a danger to yourself and others for far too long. And you need to live the rest of your life sober for your well-being and the well-being of others. There will be other terms and conditions of probation.
Judge, I think you're required to assess a fine as well.
Uh, Stand by. What is the on
I'd recommend a $500 fine just to be
Yeah.
commensurate with other cases.
you will not operate a motor vehicle until this court is satisfied that you've completed all of your programs. When you come back from safety, we're going to have a hearing here on review on the status as to other conditions of probation that this court may allow if I find that you were worthy, which would include having an auto ignition interlock system in any vehicle you operate, but you're not allowed to operate one until you were released from the substance abuse center. You must serve 10 days in the county jail, and without any jail time creditable for that, you must participate in the secure continuous remote alcohol monitoring program when you are released and you are able to operate a motor vehicle. What is the fine minimum on this? I didn't know there was one.
I believe that there is.
I believe it's, there's.
I
I
didn't
think
think
it's
the statute had
$100 is
Yeah.
what the statutory minimum is. If my memory is
$250 fine is what the court is going to assess in this case. There will be other terms and conditions of probation, which are also normally customary for this type of offense. Make sure you follow them. If you fail, your probation can be revoked. You can then be sentenced up to 10 years in prison. Do you understand? So
It should be a copy of what it said there. Now.
After hearing both sides, the judge reaches a complex decision. The court sentences the defendant to 10 years in prison, the maximum allowed under the plea agreement. But then the judge does something unexpected. Instead of sending him straight to prison, the sentence is suspended and replaced with 10 years of probation. However, that probation comes with strict conditions. The defendant must first complete 6 to 9 months in a secure inpatient substance abuse treatment facility, followed by alcohol monitoring and other restrictions. The judge makes the reason clear: this man has been a danger to himself and others for far too long. The court is giving him one final chance to change his life, but if probation fails again, the full 10-year prison sentence could still be imposed. So what do you think? Did the judge make the right decision by focusing on treatment instead of prison, or should repeat offenders face harsher punishment immediately?